Before you continue, Mr. Stewart, let me just say to whoever will be on their feet that we'll take a short break halfway through the afternoon.
Thank you. My Lord, 2 points for this afternoon. One is seeking to summarise the central criticism that I make of the judge, and which I think I half made on about 5 occasions this morning, but I think I ought to try and make it once properly. Paragraph 95 of the judge's judgment, page 75 or under. Since there is no relevant jurisdiction or indeed applicable law provision in the primary policy, I do not consider there is anything which can or should be construed as displacing the clear terms of Clause 11. 2 criticisms of that. One I made this morning, I'm not going to repeat, which is wrong starting point, displacing and so forth. The second, however, is a more fundamental criticism. What he is saying is because there is no express choice of law or jurisdiction provision in the primary policy, there is nothing contradictory between the Ppjc and Clause 11 or Clause 12. I want to focus on that second, which in my submission contains an error of logic. Inherent within what the judge is saying is that if the primary policy had somewhere within its terms, this policy is to be governed by the law of Alberta, or for that matter, the law of anywhere else, and subject to the exclusive jurisdiction of the Alberta courts or anywhere else, there would have been a conflict. But because it's not there, there is no conflict. That, in my submission, is not possible given the wording of the clause which we are considering, the Ppjc. That does not refer, shall be subject to the same jurisdiction and law as set out in a clause in the policy. It says it shall be subject to the same law and jurisdiction as the primary policy. And in my submission, that is important. It's important for 2 reasons. Logically, one can imagine 4 different situations as to conflict between the Ppjc and the Clause 11 or Clause 12. The first, if you say in terms, in the law and jurisdiction clause, it will be subject to the law of Alberta and the exclusive jurisdiction. Or for that matter, if it had said in terms, it shall be subject to the jurisdiction of any of a whole series of competent courts and with the law of New York or New South Wales or anywhere else. That would have been in conflict. The second possibility is that it is as it is, but within the primary policy there is an express choice of law clause. The third is that it's as it is, but there is no express choice of law or jurisdiction clause. The fact that there is no express law or jurisdiction clause doesn't mean that the Ppjc has no effect. It doesn't incorporate anything else. It's simply telling you that if you want to know what it is, you've got to discover what the law and jurisdiction is. But that doesn't involve incorporating something else. It's reference to a third party, to an arbitrator, to another document, another matter. These are both operative provisions. Now, my Lord, that is a very important part of my argument, but it is one in my submission which logically is correct. If I'm correct on that, and if the judge was wrong to find that there was effectively nothing to bite on, then one has to consider the various different indicia as to the conflict between the 2 clauses. And Lord, we've sought in our skeleton to run through those. I've put them in various different ways in argument to you this morning. They're in my skeleton argument, but as it were, running through them briefly, they're what I've referred to, or I referred to in argument as front against back. put more elegantly by Lord Justice Mayles in terms of looking at what appear to be the main provisions as opposed to those which appear at the back end. Secondly, the legitimate and important commercial purpose, which I say is achieved by the Ppjc, i.e. the same, as distinct from the presumed intention to have a single port of call for jurisdiction and law. Thirdly, what I say is an important indicia, which is the centrality of what I say is an important matter, which is the importance of the specifically negotiated term, that's what I was hunting for, as opposed to the standard forms at the back. All looked at in the context of whether there is the required negative stipulation that we shouldn't sue in Alberta, because that's the foundation of the jurisdiction. Now, my Lord, those are, in my submissions, my key points. But, my Lords, they are, in my submission, to be looked at, not from the position of a judge who has spent his life looking at insurance policies when they've gone wrong, and who realises that jurisdiction clauses do often go wrong, but from the practical point of view of insurers and insured seeking to look at a series of policies which are meant to be read together and thinking sensibly as to whether or not they provide for a single forum, unless explicitly agreed otherwise, allied world, or a multiplicity. Well, those are the points I wanted to make on the centrality of the two criticisms that I make. I want to pass on briefly to make two observations, one in response to a point which is made expressly in one of my learned friends' skeleton argument, and which I think I will particularly do in the light of your Lordship's observations, is the possible need for a break in the afternoon. And the second is in relation, very briefly, to touch on the Scottish law point. But I do say that the judge was fundamentally wrong to regard this as a situation where, because there is no express choice of law or jurisdiction clause, that means that there is nothing upon which the policy to provide. That is logically incorrect. It's also inconsistent with the word. So far as the two other points upon which I wanted to proceed, if your Lordships have my learned friend's skeleton argument at page, at paragraph 52.
Which one?
Oh, sorry. Tab 13, the skeleton argument for AIG. Mr. Scory at the end of a fairly lengthy paragraph, which deals with the desirability or otherwise of one shop forum shopping in Fiona Trust, which I've already dealt with, says at the end, "This is just wrong. It may be what the appellants wanted, but ignores the fact that the tower is a collection of different contracts on different terms with different counterparties. In those circumstances, it is common for the applicable law and jurisdiction between layers, to differ between layers, And the example that he gives is Axis Corporate Capital and ABSA at paragraph 54. And you'll find that authority to be found in tab 14 of the authorities bundle, which starts at page 374.
Could you just give me the reference to their skeleton again, because I didn't get it down?
Yes, my lord, it's the bottom of paragraph 64, sorry, 52 of my learned friend's skeleton argument, which is on page, sorry,
Thank you.
just put it away, page 146, I'm very
Thank you.
grateful. Now, this is a decision of Mr. Vinyl, Queen's Counsel, sitting as a deputy judge, and the question at issue, the relevant part, was as to whether or not you could imply into one of the contracts in a tower a express restricted choice of law provision. And what the deputy judge said about this is to be found at 275, page 382 of the PDF, paragraph 54. And one can see that he's discussing the existence of an implied term, and that's paragraph 53, where he applies the Marks and Spencers and BNP Paribas test, and conventionally it's got to be reasonable, necessary, etc. And what he says is this: Mr. MacDonald-Egger's essential point is that it's very inconvenient and commercially undesirable if proceedings on the primary layer and excess layers have to take place in different jurisdictions. It gives a risk of inconsistent decisions and it increases expense. I agree with all of these observations. But in my view, that is not enough to justify the implication of the term for which he contends. Well, the fact that it is not enough to justify the implied term doesn't mean that there isn't a real beneficial commercial purpose in an express term, which is what I say the Ppjc is. Now, Lord, I would accept that all things being equal, there would be a desirability of having an express term throughout all of these policies, which provided for a single forum, etc. That would no doubt be commercially desirable. I would, however, say that there is also, even absent that, desirability in that there be the same forum for all of the tower, even if there is a multiplicity of possible jurisdictions. And my lord, so far from suggesting that that's not commercially desirable, in my submission, Mr. Vinyl's decision shows that he at least thinks that there would be some desirability in relation to that. The Lord
Well,
sorry.
this paragraph doesn't seem to me to be really authority for anything.
Well, probably for present purposes, that'll do me. It's in so far as is well, what it's said to be support for is an alleged general and common position that you have different dispute resolution fora. That may or may not be the case. That doesn't deal with the fact that it is desirable to have a single one, which is, I say, what is still there in the Ppjc.
Yes.
Scotland. Your Lordships have already seen the clause only applicable in relation to the to the umbrella policy. The relevant decision which is relied upon, as it were, as being against me, is that of this court in Company Sud, which is at tab 8 of the authorities bundle, a decision which Lord Justice Christopher Clark gave the sole substantive judgment. His reasoning on this point,
Page number.
I'm sorry, my lord, 230 is where I'm going to. It starts at page 220.
Thank you.
And I'm still, I'm afraid, not sure which way out is one out, but I'm looking at paragraph
As
6.
long as we get in the vicinity, one can find the exact page quite easily.
I'm told that we've traced down, and I'm sorry, I should have found out which way. We've traced down why it is that everything's one page out. We made the mistake of putting in the hard copy bundles the certificate signed by the advocates and not in the electronic bundle. For what it's worth, my own experience is there's always something which puts it one page out, but there we are. Paragraph 16 following, and the relevant phrasing is the phrase, this bill of lading and any claim or dispute arising under it shall be subject to English law and jurisdiction.
Is this under the heading of Scotland, or is this the other point about exclusive or non-exclusive?
Well, it's exclusive or non-exclusive, my lord, in relation to. Sorry, I'm on the heading of exclusive or non-exclusive.
Yeah, sorry, you said Scotland, but you're really under the other heading.
Yes, I am. I'm sorry, my lord.
Okay.
I apologise. Doesn't make note taking any easier.
No, that's fine.
Now, for present purposes, I make the two obvious points. One is that there is nothing which this case considers equivalent to the Ppjc. So plainly, what is being considered here is simply, as it were, the shall words. And secondly, paragraph 63, the judge does expressly accept that a non-exclusive English jurisdiction clause is not worthless or odious, even when there is express provision for English law, and that there can generally be only one law governing the contract, that there can be more than one court having jurisdiction over disputes. The natural commercial purpose of a clause such as the present is to stipulate what law will govern and what law shall be the court having jurisdiction over any dispute. Well, that may be, but if you look at the contract as a whole and you find that you've got other contrary indicators, you can come to an alternative conclusion as a matter of construction of the contract as a whole. And if your lordships will be kind enough just to go back to our skeleton argument. We deal in particular with this at paragraph 74.
Sorry, just again, I need the page number.
I'm sorry, my lord, 123, and we're at paragraph 74 of our skeleton argument. On the English, the words used in clause 11, the commercial court shall have jurisdiction, as the court correctly identifies the words shall as imperative and directory. But what we say is important is that the imperative or direction is directed at the commercial court and not the parties. And secondly, we do draw your lordship's attention to the fact that such words instructing the commercial court to accept jurisdiction, as opposed to instructing or directing the parties to submit their dispute to the commercial court, are apt for a non-exclusive jurisdiction clause, and indeed mirror the relevant provisions of the CPR. So if you're looking, as it were, at the contract as a whole, and one is looking not at exclusive, but shall have jurisdiction, then in my submission, there is good ground, given the Ppjc, for finding non-exclusivity, and that is a way of reading the matters to a whole, reading the provisions together as a whole in relation to Clause 11, although obviously not Clause 12 of the first and third excess policies. And in relation to Scotland, the words issued in Scotland are intended to have some real effect. They are in there. The judge has said, well, issued means issued out of London. We would say more naturally they apply to where the identified insured is based. As you'll have seen, the identified insured is in Scotland.
And there are lots of insured, aren't there?
Yes, well, that's why I said the identified insured is in Scotland.
Oh, I see.
Just to take you back to the...
Yeah, principal insured, I think they're called.
Yes. Yes, well, there are lots of insureds. We've got all sorts of subsidiaries.
Yeah, as you'd expect, yeah.
Quite. The one who's identified, as it were, on the very first page of the policy
Yes,
is a Scottish company. The Lords...
in that case, if you say the words in Scotland must be intended to have some effect, but on your construction, on that approach, the rest of the clause has no effect. I mean, it can never be England because it's always Scotland.
Yes, for these purposes, my lord, I'm being somewhat disruptive in the sense of, for these purposes, they need to rely upon that clause to attribute jurisdiction here, hence the whole point about being negative and so forth. They need to establish a negative covenant on my part not to sue in this case, Alberta. It's a point which really goes on this analysis to whether they've achieved that necessary standard for the negative covenant.
Yep.
Yes, could I just read to you the words of these are the service out provisions of the civil procedure rules. The claimant may serve the claim form of the defendant outside of the United Kingdom, where for each claim made against the defendant to be served and included in the claim form, little a is irrelevant, a contract contains a term to the effect that the court shall have jurisdiction to determine that claim. Shall have there is plainly includes non-exclusive jurisdiction. My lords, those are my submissions.
Can I just ask you one thing, which I'm still in a muddle about? What is the difference between a main clause incorporating by importing terms and conditions that are not set out in the policy document, and a main clause which incorporates or imports terms and conditions that are set out in the policy document? Because we've got a well-established set of principles about what you do if you've got an imported and an importing clause. And I just at the moment, I understand your submission about how the risk details of the main clauses and so on and so forth. This is a different point. What we do have in the risk details is the importation of another set of clauses.
Lord,
Are they not subject to the normal rules about importation and non-importation?
Lord, the reason I'm, I think, having some difficulty with your lordship's question, which may, I think, be a way of, well, I hope is a way of answering it, is this. I would understand in an insurance policy that where you have one document numbered sequentially from 1 to 30 or 1 to 32, those all to be terms of the policy without importation, if I can put it that way. I would understand a circumstance where there would be importation where you have one of those terms which said 4 terms or 4 conditions, see the Italian general
Right.
terms of contract.
So
and so
if,
forth.
if it had done that, if instead of attaching the terms, because it says see it, conditions see attached. So if, I think you're accepting that if it had said see, whatever they may be given name, see conditions A, but they weren't attached, they would have a greater status in the terms of the conversation or the discussion you've been having.
Oh, my lord, no, I'd put it the other way. I'd put it the other way around. My submission is this: in terms of contractual status, and this is one of the points which one gets out of the building case.
Your submission is
modern buildings is that you in general you attribute a higher status to the documents which form the contract than those which are incorporated by reference into it.
So your submission would be that the principles which are fairly well understood about incorporate what you do if you've got a conflict between incorporated and incorporating terms simply doesn't arise where you've got an insurance policy that incorporates by reference.
I think I'd better start from the beginning, my lord. What I would say is this: in this policy, I do not assert that there are any terms properly to be seen as being incorporated by reference. And just to be clear, what I would say is being terms.
Is a 32-page or a 30-page contract.
And if instead of, to take your lordship's example, if instead of having conditions 1 to whatever it is, 14 or whatever they are, which include 11 and 12, it had said C and then some identifying characteristic which allowed you to find what those terms were, but didn't otherwise deal with them, that would be what is meant by incorporation. And those would have what your lordship referred to as fairly well-known principles attaching it. I mean, in essence, I can paraphrase, you try and read the whole thing together, but if you can't work, then you give primacy to the ones which are, as it were, expressly set out in your contract document. So that would be my submission as to how it works. In this case, the reason I suspect I may be having some difficulty with your lordship's questions when you said, well, I think it's a point which doesn't necessarily work in your favour. Regardless of that would be my submission as to how it works. I would not accept that it would be appropriate to describe as incorporating terms by reference where you refer to a method of ascertaining what they are, but the operative provisions are contained within the contract. And so to give you an example, if it says the interest rate applicable during the period of the contract shall be the base rate from time to time plus 1.5%, that tells you what it is, but you have to look elsewhere to find out what the base rate is.
Yeah, I think you're probably right about that. I'm just niggling away at where the differences lie, but that's fine. Thank you.
Right, well, thank you very much, Mr. Stewart. Now, who's going next?
My lord, it would be me.
Right.
I'm grateful.
Have you and Mr. Scory discussed how you're going to deal with this, or
Yes.
what's going to happen? Yeah?
Yes. So I'm going to be taking the main burden of it, and Mr. Scory is going to be pointing out all the points I've missed, no doubt. So if I may just outline the issues that I'll be addressing before you today, my lords. There are 3, as you've seen from the skeleton we've served. First of all, focusing on the proper meaning and understanding of Clause 11, i.e. Clause 11 in the umbrella policy, my client's policy. Second, dealing with the Scottish issue, if I can call it that. And then third, doing the iterative process, so to speak, of asking how does Clause 11 fit with the rest of the contract, and in particular the points made by Mr. Stewart regarding the Ppjc. What I don't understand to be part of the grounds raised against Mr. Justice Jacobs' judgment is any allegation that the test for the issuing or the ordering of an anti-suit injunction was wrong. Quite the opposite. the principles as encapsulated in the Kaplan judgment that Mr. Justice Jacobs relies upon were not controversial below either. The reason I mention that is because, as I will come on to dealing with the points raised by Woods, and indeed the points that Mr. Stewart has made this morning, there is this nebulous concept of comity floating around here. And at points, I think it was my Lord Justice Phillips, raised the question of the procedural bar. Is this really what the case is about? The short point is, as far as the grounds are concerned, that isn't what the case is about. And I would be saying the case is about what does the contract mean, and the best place to start is what does Clause 11 mean in the umbrella contract, in the umbrella policy. Because while, as my Lord Justice Phillips is right, where you start might not make any difference in the final analysis, I say you've got to start somewhere. And what that certainly doesn't exhibit is what my learned friend Mr. Stewart says is some sort of inherent bias or confirmation bias, maybe he might put it this way, in the interpretation process. Just because you're looking at Clause 11 doesn't mean you assume anything about Clause 11 before you interpret. I'd also go further to say that two things. A, that's logically the place to start anyway, not least because when I was before Mr. Justice Cockrell and Mr. Justice Jacobs, of course, I was relying on Clause 11 to justify the very application I was making. So if I'm wrong on Clause 11, I don't get very far. So we've got to work out whether that works. Equally, because it's an iterative process, as is explained in Wood and Capita at para 12, which we'll look at if needed, you have to pick a point and then go backwards and forwards, test it. And what my learned friend has seemed to do at times is seek to elevate appeals to commercial purpose, common sense, as a starting point in and of itself. The commercial purpose point, as is obvious from the authorities and well known to this court, is of course just one tool within the toolbox of the lawyer or the judge in order to test and understand the words used, and thereby divine the intentions of the parties. And that's important, again, as we will come to see, when one's dealing with allegations or arguments based on one-stop shop or permissive approach or any of these nebulous arguments, I have to say, my learned friend has put forward to justify his approach to the interpretation of this policy. So that's why, if I may, I will start looking at Clause 11. This obviously is slightly different, as my learned friend Mr. Stewart pointed out, from the position that my learned friend Mr. Scory may address you on, because our clause is distinct. If I could take you and just look at the clause for one particular moment, we find this in the core bundle. And that's core bundle, page 95, by my pagination. My lords, you'll see clause 11 there at the bottom of the page, and it does two things, we say. First of all, as the title might suggest, chooses the law, but it also does chooses the jurisdiction. Of course, the Scottish point comes in here, but I'll deal with that later. The reason why I start here is we say, as a matter of the ordinary meaning of the words, it is clear and mandatory as to what the choice of law is, and also the jurisdiction. And that is, in the case of the jurisdiction, identified by the phrase, shall have jurisdiction in respect of any dispute under this policy. I say, and before we even look at the relevant case law in it, the word shall denotes a mandatory nature. It's something that the parties have to do and agree to do. Equally, when it uses the phrase any dispute, this is clearly a clause that's meant to encapsulate quite a wide range of instances, and indeed this dispute underlying in Canada here. And equally, what it is inconsistent with is any suggestion that the parties, when agreeing to this clause, is agreeing to a permissive or floating jurisdiction. Further, the fact that it is clear on choice of law is a good indication in and of itself in supporting my analysis that this is meant to be and intended to be an exclusive jurisdiction clause. I say that, A, because as a matter of principle, one has to ask at the inception of a policy or the agreement of a contract what law governs it. It doesn't make a lot of sense for it to be floating, to be crystallised at some point in the future. Going back to the putative broker advising the businessman, if asked which jurisdiction or which obligation am I under, the first question is, well, which law tells us that? You have to have a choice of law at the beginning. And that choice of law is indicative and consistent with an exclusive jurisdiction in England. And the reason I say that is the observation made by Mr. Justice Foxton in Generali. So if I may take you to tab 12, in the authorities bundle, my second authorities bundle. My lords have been taken to this on a number of points, and not least because Mr. Justice Foxton was struggling with similar issues as the ones that Mr. Justice Jacobs did.
It's paragraph 92, isn't it?
It is paragraph 92, yes. So that is at page 349 in the bundle, or 4234 of the report. That is also consistent with the general principle that one can see from the case of Armar Shipping Company and case Agrienne, which is at tab 2 of the authorities bundle.
Is there anything in Global Maritime and OW that we benefit from knowing about?
I don't believe that authority here, but from my recollection, there are useful things to derive from that that may be familiar to the court. But certainly the proposition generally is that in paragraph 92.
I mean, any askers, he cites that case as the source of that position.
Well, I would say, I look at Mr. Justice Foxton's judgment because that's as good a way of deriving the principle I seek to derive. Equally, as I've said, I think it's true as a matter of principle, and thirdly, it's consistent with Armar Shipping, which is at tab 2 of the authorities bundle. This is a situation which is one that's relevant to the more general permissive floating point made by Mr. Stewart, which we'll come on to later. But if I could take the court to page 23 of the bundle, or 215 of the report. And if I could ask the court to read from C, starting Mustle J, as one would expect, to over the page at the end of A, and then I'll make my point briefly. There are 3 points I take away from this. The first on the issue I just addressed you, my lords, which is the antipathy towards the notion of a floating choice of law clause, as expressed by Lord Justice McGaw here, is consistent with why Mr. Justice Foxton says it's a good indication of a clause like Clause 11 being intended to have the exclusive effect that we say it does. The second point is when one looks at, for example, the argument relating to the permissive approach, one can see that the permissive approach, if adopted in the way that my learned friend Mr. Stewart would suggest, would have to cut across into choice of law as well. Because the effect of my learned friend's argument is essentially to ignore Clause 11 entirely and to treat the Ppjc as a floating choice of law and floating jurisdiction clause. And that would be, again, antipathetic to what we see in this case. The third point is also articulating when we come on to look at the mechanism of a tower such as this of insurance, which is, are there circumstances in which, if jurisdiction is to be crystallised by the primary policy, are there instances where actually you might get into the umbrella or the excess elements of the tower without anything crystallising on the primary policy? And it's analogous to the points that Justice McGaugh makes here regarding the obligations which are forthwith and prior potentially to any dispute crystallising. And that's why you need, at the point of agreement, a choice of law to be identifiable or identified, and it is important to have an understanding of where disputes will be litigated, arbitrated, or otherwise resolved. Because there may be many things that occur even upon agreement, and there's certainly, in the case that we're dealing with today, many instances where you might have to ask yourself, where is the dispute to be litigated or arbitrated before anything happens on the primary layer? So that's what I take away from this.
Forgive me, but why is there an issue over floating law, proper law, with the Ppjc?
So if one looks at the Ppjc, that's going back into the core bundle, if we may. So the Ppjc, for my purposes, are at page 94. This is the preceding page to, of course, clause 11 that I was looking at earlier. And here we have the Ppjc, first paragraph or first part. Any dispute concerning the interpretation of the terms, conditions, limitations, exceptions, or exclusions of the policy are understood and agreed by both the insured and the insurers to be subject to the same law and the same jurisdiction as the primary policy. I.e., for present purposes, my learned friend Mr. Stewart is saying, well, look, his analysis is that there is some floating jurisdiction clause that crystallises potentially on a dispute being resolved or a claim being issued in Canada. But if that's correct, indeed this is the point that Mr. Justice Jacobs made in his judgment below, it would also follow logically that he's having some sort of floating law clause in there as well. I.e., if, as we know, we'll come on to look at how this works in a minute, the primary policy is to be described as the underlying CGL policy, and there is no choice of law expressed in that, and there is no choice of law that has been identified, the logic of Mr. Stewart's argument runs the risk of coming up against Lord Justice McGaugh's antipathy towards quoting law clauses. So I appeal in that to say that he can't have his cake and eat it too.
I'm not understanding it. Where does choice of law come into it? All this says is that the choice of law in this clause, what's been chosen is the same law as the primary policy.
Yeah. And no law has been chosen in the primary policy.
But where does choice come into it?
Well, it assumes, I would suggest, much as it does regarding the jurisdiction of the primary policy, that a choice has been exercised. I.e., looking at the primary policy, can you answer the question posed by the Ppjc? What is the law of that policy?
Every policy will have a governing law, proper law.
Yes.
So I don't see any difficulty in saying the law on governing law, proper law, saying the law of this policy should be the same as the law that governs the primary policy. It may be that you have to work out what that governing law is on normal principles.
Yes.
But I'm not sure, I don't see any difficulty with saying, I don't see how you could possibly read this as saying that you've got a floating proper law.
Well, the point that I'm seeking to make and will develop shortly is, of course, the value of certainty. And when you're contrasting Clause 11 with the Ppjc, where Clause 11 tells you what the choice of law is, there's no risk of floating or no risk of uncertainty there. You look at
Well,
the Ppjc.
floating law and uncertainty as to what the non-floating law is are different things.
Well, they are materially different things in the sense that, as I understand your point, my lord, to be, if one, at the point of inception of the umbrella policy, was to look at the question begged by the Ppjc, one might, with proper inquiries, come to a view as to what the choice of law of the underlying primary policy could be.
Well, the applicable law.
Or the applicable
governing law, whatever.
Yeah.
Not choice of law, because there is no choice of law.
No, the applicable law would be, but why that is relevant to certainty, one doesn't need to do that when one looks at Clause 11, because Clause 11 tells you that. So going to the interpretation of what the parties intend in the umbrella, the certainty and the clarity is in Clause 11, well, that is lacking in Ppjc, because it may be that after inquiries and consideration, one could reach an opinion or view as to what a court might say the law of the applicable law of the underlying primary policy is. But what it doesn't do is tell you in the body of the primary policy. And that's where the certainty issue arises.
Well, Mr. Stuart says that the Ppjc primary policy must have a governing law, even though he hasn't told us what it is.
Yep.
But you may only be able to ascertain what the governing law is going to be when you know which court is going to be deciding that, because the rules for determining governing law may be, and I suspect are, different in, for example, England, where you've got the regulation, and Canada, where I don't know whether they have equivalent to our common law rules or whether they have a regulation of their own.
Yep.
Other jurisdictions may say different things. So, although it can be said that there is a governing law, it is unknowable what it is until you know what the jurisdiction is going to be.
Exactly. And that's where the problems with the uncertainty comes in. And that's why I draw a contrast between what the Ppjc says and what Clause 11 says, which leaves one, say for maybe the Scottish point, to be clear that it's English law. And that's the deal struck, and indeed the deal that should be upheld. And the point that I started with, following Mr. Justice Foxton, if there is any doubt or you're seeking to interpret the terms of Clause 11, the fact that that choice of law exists at all within Clause 11 is a good indicator that the interpretation I'm putting forward is the correct one. So moving on to, is there support within the authorities for this type of approach? Now, it's suggested in Mr. Stewart's skeleton argument that there was some undue weight given by Mr. Justice Jacobs to the decision, the judgment of Lord Justice Christopher Clark in the case of Hinpro. Two things, first of all. Mr. Justice Jacobs didn't do that. He did the right thing, you would say. He considered the natural meaning of the words, and then he considered, is there support out there for the conclusion he's come to? And he looked, for example, at the fact that there's a contrary distinction with respect to the reference to Scotland. Why would it mention, for example, within the clause, the potential Scottish carve-out? That's because it should be England as exclusive jurisdiction unless there is a Scottish connection. That supported his interpretation of the word shall and the mandatory nature of the words used. He further found support in the analysis provided by Lord Justice Christopher Clark in Hinpro. So that's at tab 8 of the authority bundles, starting at page 220. At 230, we see learned Lord Justice's analysis. Pausing here, for my part, there are a number of points within this analysis that cut across a number of the points made on this appeal, but for the present purposes, the key one is at para 61. If I could ask my lords to read 61, I'll just make the point very briefly.
Just to save me scrolling through, can you turn to the page?
Yes, sorry, it's page 230 or page 11 of the report.
Thank you.
So the takeaway from paragraph 60, of course, is analysis of the word phrase shall be subject to, and that being imperative and directory. While, of course, exactly the same words or phrase doesn't appear in this clause, it is materially the same, I would say, and certainly what the ordinary reader would understand it to mean. In addition, and I suggest that the rest of the analysis is very helpful, he makes the following points. If, for example, we go to his third point over the page at paragraph 66, and this may be, to some degree, a response to my Lord's query regarding Mr. Justice Foxton's justification for the point of paragraph 92, as I mentioned. We can see that at 66, Lord Justice Christopher Clark says there is obvious sense in making both English law and English jurisdiction mandatory, whilst foreign courts may, but will not necessarily apply English law, if that is what the parties have agreed. England is the best forum for the application of its own law. That, in a sense, is the commercial common sense justification for why choice of law is a good indicator of exclusive jurisdiction being in play, i.e. the point Mr. Justice Foxton made. A further point follows from his sixth point, and if, my lords, I could ask you to read para 69 through to para 74. The point here is a suggestion that somehow the exclusive jurisdiction clause is in the favour of an insurer at the detriment of an insured. My point is it's value neutral, particularly when you're agreeing the contract, when you don't know what the risk that might eventuate is. So if I could ask you to read 69 through to 74, one will see that point, I hope. One can see from paragraph 74 there the recognition that until one actually gets to a casualty being suffered, a claim being made, questions of which form is best or worst for one particular party don't crystallise. At the time of agreeing the contract, and in this case the time of agreeing clause 11, it's a value neutral point. And in fact I would go further to say, as I would suggest is recognised by 74 in the other paragraphs, that there is a value uncertainty here, because at least everyone knows where they have to go once one of the unknowables or unknown risks eventuate. Further, in support of the appeal to the analysis of Lord Justice Christopher Clark in Hinpro, on the question of the meaning of the words used, support can be gained from the commentary in the textbook written by Mr. Joseph, Jurisdiction and Arbitration Agreements, which is right at the end of the second bundle of authorities at page 566, tab 18. Now, paragraph 4111 onwards, there is consideration of these issues, and there are 2 points. I don't need to take you through in detail this. The first is the writer of the book supports the notion the word shall denotes exclusive jurisdiction, and also points, the second point, that perhaps getting caught up with some of the formalism that is existing in some cases, such as focusing on whether something's transitive or intransitive, can get quite arcane. The simple point here, and I brought support from the learned author and from Lord Justice Christopher Clark, is the judge was right to come to the conclusion that the phrase shall have jurisdiction in respect of any dispute on the policy was exclusive in nature. There are essentially 3 points taken by Wood against this, which I've covered to some degree already, but it is in summary. Wood argues that Jacobs, Mr. Justice Jacobs, relied too heavily on INPRO. That's not the case for the reasons I've said. It's just part of the sense check, having identified the meaning of the words on the iterative basis in the usual way, in the proper way.
Well, in Hinbro, there were, I think, 7 factors which collectively led Lord Justice Christopher Clark to his conclusion. I think you pick on 3 or 4 of those, and say they help you, but the other 3 have got nothing to do with that case. So you've always got to look at the whole thing, obviously.
Which is why I started with the words, looked at the ordinary meaning, and in a sense, this justifies the interpretation I put forward today, as indeed it did in the judge's mind. Further, what I mentioned earlier, the confirmation bias or bias, one can see immediately that doesn't come in here because one's looking at the words and what they mean. The testing, the iterative process, is when we look at what the Ppjc might mean in this context, and again, that's what the judge properly did. The third point, which I haven't addressed, that Wood makes, which is at paragraphs 74 and 75 of the skeleton, it is essentially to suggest that the mandatory language, i.e. accepting it's mandatory, is somehow directed at the commercial court rather than directed at the parties. The first point is that is not the plain meaning of these words. One can see that this is focused at the disputes. The disputes are in the hands of the parties, not in the hands of the court. Further, it makes no sense that a non-party of this contract would somehow be directed to take hold of these disputes. It's inconsistent, fairly, with the wording used. So, if we can see, for example, the notion of shall have jurisdiction in respect of any dispute under this policy. So it's policies and it's a dispute of the parties in their hands. And rhetorically and finally, well, even if this was focused at the commercial court rather than the parties, what's really the commercial court meant to do about it? The parties hold the dispute in their hands. Is the commercial court meant to do some active, proactive step in the fashion that Wood seems to suggest that they would? So that third point made by Wood in the skeleton, I say, simply goes nowhere. So in broad terms, those, my lords, are the reasons why I say it is an exclusive jurisdiction clause, and that's the right place to start. Before I look at the interface with the primary jurisdiction clause, obviously there's a question as to whether the Scottish point has legs or not, so to speak. Because obviously if the Scottish point is effective, then my client shouldn't be in the courts in London, but the courts in Edinburgh perhaps. The short point is the natural meaning of the words in the clause clearly dictate that this isn't a Scottish case, so to speak. There are 3 points effectively on this. The first is, as a matter of the evidence, it's uncontroversial that this was a policy issued by a London insurer in London to London brokers who were acting on behalf of Wood, and that the underwriters were engaged and employed in London, and this is all set out in the witness statements in the supplemental bundle. And this can only lead in itself to the natural and ordinary meaning that it was issued in London, which is of course the phrase. The second is, when you're talking about issued in, I can suggest that that must denote a geographical location. The word in carries that. The act of issuing is something you do somewhere. And if it was said that the place of the insured, in this case the principal insured, Wood in Edinburgh, was the dictating factor, it would have said issued to, not issued in. So that's the second point. The third point that Wood takes is that, well, if that's right, then this clause or carve-out would have no function at all, because this policy was issued physically in London and would usually be issued physically in London and wouldn't be in Scotland. Well, I say that that doesn't necessarily follow at all. Not least one can think of potential scenarios where you might have this policy or type of policy like this issued in Edinburgh, say, for example, by way of a cover holder, or indeed by a local broker in Scotland. So it does have a function, it's not otiose. And even if it doesn't have a function, the Scottish point is a carve-out from Clause 11, and one doesn't need to sacrifice the totality of Clause 11, including the parts that I rely upon, simply to make it work in the way that Wood wants it to.
Well, I suppose the clause only makes sense on the basis that it is drafted before it is known where the policy is going to be issued.
Exactly.
Because if it is known that the policy has been issued in London,
Yep.
then there's no point of having a Scottish carve-out. If it is known that the policy has been issued in Scotland, then the rest of the clause doesn't make sense.
Exactly. And of course we don't know one way or the other as a matter of evidence, and certainly as I understand Mr. Stewart's case, is that this somehow is some form of standard term which isn't bespoke between the parties. And so if you're asking what is the purpose of the carve-out, I hope you've explained it does have a purpose, because there are scenarios where it may well work out. So those are a quick counter through, first of all, the first point, which is it exclusive, Clause 11. We've looked at the second point, is this a Scottish policy or not? I say it isn't. So looking at the third point, which is the interface between the Ppjc and Clause 11. Of course, I start on the premise that Clause 11 is exclusive within the natural meaning of the words used in that clause, and that is why that is a foundation for my client to come to the court and get through the gateway, so to speak, and to satisfy the terms of the guidelines on the issuing and ordering of anti-suit injunctions as set down in the Cat case, for example. But what Wood is seeking to do, as you've heard at length, is say, well, hang on a second. The Ppjc is of such clarity and force that it trumps the clear words that I've identified for Clause 11. We say that's just simply wrong. And it's wrong on many levels. The first is trying to even understand how the Ppjc might work. And certainly the terms used are not as clear as my own friend would like to think. If we could look at the Ppjc again, which is at page 94, now, remembering that one of my learned friend's points is that there is this permissive or floating point. Obviously, query how that fits with one-stop adjudication argument as well, but let's take the floating point on its face. The way that the Ppjc is phrased by reference to a primary policy, firstly, we don't know from the actual clause itself, nor in any of the definitions, what the primary policy is, so we've got to hunt for that. But there is a solution to that, and we'll come to it. The second is it talks about the same law, the same jurisdiction, the said territory, such court. So it's talking about a singular place or a singular law, and for our purposes, particularly a singular territory. So if this is to have meaning, one would hope that whatever this primary policy is, it will tell us what this singular territory is, the said territory or such court is. As I said, there's a hunt to identify what the primary policy referred to here is, and I say the likely answer, as accepted by the judge, is just above. It is the CGL policy. So, going back to the putative businessman that my learned friend relies upon, so my putative businessman, who I say should be taken to have read the whole document, looks at this and thinks, okay, well, maybe it's the primary policy in the sense of the CGL policy. Okay, so I should have a look at that. And then he pauses and goes, well, actually, Clause 11 has already answered these questions, but let's pause there and have a look at the primary policy. So we know that the primary policy is actually one of 70-odd policies underlying this umbrella, sitting under the umbrella, which cover a whole series of different risks: motor, professional indemnity, employer's liability, public liability, etc., in a variety of different jurisdictions with a variety of different terms. But that putative businessman has gone hunting and has found the CGL policy and decided that's the place to look, or has been advised that's the place to look, and then looks. That policy tells him absolutely nothing about where dispute should be litigated. It doesn't tell him what the said territory is or what such court is. So you have an immediate problem here in the Ppjc, which is effectively meaningless to the reader, because it's telling you to go and look somewhere that has no answer when it comes to where disputes have been to be litigated, which is, of course, why my learned friend is appealing to this notion of a permissive or floating jurisdiction. And then you must consider, well, okay, let's give my learned friend the benefit of doubt, because I say that the answer lies there. It's meaningless. Let's say there is a clash. Let's say the Ppjc has a meaning and is telling the reader something about jurisdiction. And so on the one hand, you've got the clear terms of Clause 11 saying you need to go to the commercial court. And on the other hand, you have the Ppjc. And let's assume, for the sake of argument, that there is an inconsistency. So what's the answer? Well, I suggest the answer is that which the judge found. We have here, in the Ppjc, essentially an attempt to incorporate what's described as the primary policy. And that's likely to be the CGL policy. And if it is incorporating that, then certain consequences follow. So there are 2 points there. First of all, my learned friend, as I understood it, was saying, well, it's not incorporating anything at all. I'll answer why that's wrong. The other point is, well, what happens if it is incorporating? Was the judge right to apply the guidance from the courts in the way he did? And I say the answer is yes. So with respect to, is this implying something? Well, going back to the language at page 94, where we see the Ppjc, one can see reference to the primary policy. It's talking about the same law or the same jurisdiction. It's talking about this policy being understood and agreed by the parties to be subject to that. And so the natural meaning of these words, I would suggest, is, putting it in broad terms, if you want the answer, you need to look at the policy underlying it. That is incorporating those terms. And it isn't equivalent to one of the points my friend made towards the end, with simply saying it's base rate plus 1. There's a independent or objective source of data which you might use as an anchor to understand a contract, which might vary over time. This is saying go and look at another contract, and that will give us the answer. That is the incorporation. So with that in mind, the courts assist us in telling us, I suggest, how one deals with a clash of incorporated terms. The simple point is that if there are inconsistencies, then the bargain, this contract, is what should stand to be preferred. Because this is the deal that was done, and the incorporation is, the terms that are being incorporated was not in and of itself a product of that bargain. It was part of the bargain. So one can see from clause 11 that there is a clear decision to nominate the commercial courts to have exclusive jurisdiction.
So your submission would be the same on this point, even if the primary policy actually said in terms Alberta law and jurisdiction?
Yes. But of course I don't have to put it in that way.
No, I appreciate
because
that.
it doesn't. As I said, this is assuming that the Ppjc has a meaningful content in the way my learned friend suggests. And the reason I say that is, first of all, the commentary in Lewison, which is cited in my skeleton, but for your note, my lord, it's at paragraph 3.83. That's in the second bundle, tab 17, page 560. But equally, and I will turn to this, it's abundantly clear in the decision of modern building, which is the first of the authorities in the bundle. This is dealing with an old form construction contract and arbitration clause. And the proposition that I rely upon is towards the end, at page 12 of the bundle, page 1289 of the report. And if I could ask my lords to look at E through to G for the proposition I say. I focus on the phrase, in my judgment, subject to this, that if any of the imported terms in any way conflict with the expressly agreed terms, the latter must prevail over what would otherwise be imported. I focus on that because one of the points taken against me by Mr. Stewart is that if there is this principle, which I say there is, it is restricted to the incorporation of entire documents. That's clearly not what the Court of Appeal for here. And indeed, I would say would make no rational sense anyway. And it's better to apply a term-by-term basis, certainly to find that any incorporation by the Ppjc is inconsistent with clause 11 and should there be not treated as effective. So, pausing there, those are the...
If we're pausing there, is that a convenient moment for a short break?
Yes, it would be.
Yes, all right, well, we'll just take a few minutes.
I'm grateful.
All right.